Hello students, welcome to our Learning Plan 6, our last learning plan for our class. The overview. Accountability is an important consideration for police administrators who will have trouble maintaining control with it. That is, if subordinates or even administrators are not held to answer for their action, crime control and police services are compromised. Administrators must take steps to promote accountability among their subordinates. Competencies and learning objectives for Learning Plan 6. Competency. Defend the importance of evaluating major issues in police management outcomes for criminal justice planning and innovation. Okay. Learning objectives. Describe the role of ethics and professional codes of conduct in guiding ethical behavior. Describe the role of assessment centers in creating and enforcing guidelines. Apply company and professional codes of conduct to specific situations and leadership situations. All right. The assignment is your typical 1,000 to 1,500 word paper and an APA format explaining how the exclusionary rule in criminal prosecution can promote accountability within police organizations. Include at least 4 academic or professional sources to support your work. I am going to thoroughly discuss the exclusionary rule for the substantive portion of the seminar today. You are free to use anything that I have provided in this seminar, which is going to be in PDF file format attached to the news item that houses the link to this seminar. You're free to use it in your paper if you would like, your LP6 assignment. Discussion 6.1. What are the methods for promoting accountability from the outside? What are their strengths and weaknesses? You might consider community review boards. That's a key word you might consider using and see what their role is if they're established. And what their role is regarding accountability for police organizations that they review. 6.2, what are the methods for promoting accountability from the inside? What are their strengths and weaknesses? This is primarily going to be internal affairs, but I also encourage you to look at police culture and conduct, and you're free to go back to the previous Learning Plan 5, where there were 3 different types of management styles. It was leadership by example, and then strictness, and then openness, and how those management styles affect their subordinates when it comes to misconduct, fraud, false reporting, and whatnot. So that's another avenue you could take in this 6.2 discussion. 6.3, what is a police bill of rights and what is it designed to accomplish? I pulled up the police bill of rights pursuant to Florida statute before I recorded this seminar, and is what it is in my state, at least, is a series of rights that a police officer has when they are being investigated under a variety of circumstances, being suspended with pay, being on administrative leave. It just provides the due process and evidentiary requirements that a police officer is entitled to by right. It may or may not be the same in your state. I encourage you to look it up in your state and provide us a one-over or synopsis of what the general theme is, and maybe a few examples in the discussion board. Again, office hours are conducted through my Adobe Connect. My office hours on Tuesday at 6 p.m. Mountain Standard Time or by appointment. I will send out the email with the invitation tomorrow on Tuesday. I will be available between 6 and 7 o'clock tomorrow evening Mountain Standard Time. It is, again, always preferable to give me a phone call at my office. I return phone calls quickly with no question within 24 hours. Emails are faster. So please do not wait for the office hour to contact me if you have a question. So now I'm going to go ahead and occupy the rest of the seminar with the exclusionary rule. The main purpose of the exclusionary rule is to deter the police from violating a person's constitutional rights. If the government cannot use evidence obtained in violation of a person's rights, it will be less likely to act in contravention of those rights in future situations. Is what this means, to boil it down, is that if police officers cannot use evidence obtained, or the prosecutor cannot use the evidence obtained by the police officers because it was seized illegally, meaning it violated the warrant requirement, maybe it was the Miranda rights, whatever the violation is of a defendant's rights, then the prosecutor is going to turn around to the police officer and maybe even provide an overall brief to the chief of police for that jurisdiction and say, these are some instances of what specific instances of an arrest or where I, as the prosecutor, I could not use the evidence to prosecute the case because of the illegal obtaining of it by the officer. And when I prosecuted, I never saw any direct intentional violations of constitutional rights to obtain evidence. When I did see illegal evidence seized or somebody illegally searched, it was in good faith. It was not because the police officer wanted to go after the person or get something they believed to be there maliciously. They just did not know the law well enough, or they misinterpreted the surrounding facts and situation to their favor for a stop and search or whatever it is, stop and frisk or an arrest for pursuant to probable cause. So I never saw any intentional. Now there are intentional, because the intentional cases, some of them have gone through to the Supreme Court, and that's where the Supreme Court establishes case law under criminal procedure. So it's there, but it's rarely, in my experience and everything I've read and seen, intentional. Generally, and fruit of the poisonous tree, you may have heard this before in your previous criminal justice classes, but I'm going to go ahead and review it. Generally, not only must illegal obtained evidence be excluded, but also all evidence obtained or derived from exploitation of that evidence. The courts deem such evidence the tainted fruit of the poisonous tree. So, for example, arrest without probable cause and a confession follows. The confession must be excluded because it is the direct result of an unlawful arrest. And it's a Supreme Court case holding Taylor versus Alabama. So what defense attorneys did, and when I was looking at my cases and building my cases to prosecute, I would start at the very beginning. Why did the police officer pull the car over? And I'll never forget, I had one case, and I actually had to go against one of my professors. He is also a private defense attorney. I mean, the guy, he's well known in all of Northern Florida. He does very high-end cases. So it was a high-end client in town, and I had been given the case on my docket. I took over somebody else who had to go on emergency vacation. And the defense attorney filed a motion to determine the legality of the stop. So there are five or six, depending on how it's determined, or how you look, or how the individual attorney looks at it. There's 5 or 6 major doors that have to be opened and successfully walked through to get or obtain a DUI conviction in trial, or to even, if the defendant has a good defense attorney, argue that the defendant should plea. And the difference between public counsel or public defender and a private defense attorney is that public defenders in Florida have an average caseload of 400 cases. Private defense attorneys will carry 30. So people that have money are paying for that private defense attorney to check every box and file every motion possible to get evidence dismissed, to get evidence suppressed, confessions. They challenge everything from the very beginning. And I always found that really interesting, because at first I'm sitting here thinking, why they're going to drag this on for a year with all of these motions that, here this guy wants to go to court and he wants to challenge the stop. That's not even, stopping the car, the police officer hasn't even gone up to the car yet and started talking to the driver, which is a whole nother hearing. Actually, it was 2 hearings, okay? And so, in one case I had. So the police officer had written on the summary, or the police report, that the car had a broken tail light, meaning it wasn't working, and the light over the license plate that lights it up was not working either. Now in Florida, brake lights have to be visible from 300 feet back. And if a brake light is out, that is a reason to stop the car because that is considered a public safety issue. And I completely agree with that. As far as taillights, those aren't as important. They don't have to be red. And there is a requirement that the license plate is clean and it's illuminated. And those are all criminal laws in Florida. So the police officer pulled over the vehicle because there was a blown out or a missing tail light, and then the light over the license plate wasn't lit. And the defense attorney goes in there, and he didn't know his name. His first name was Craig. He didn't know it was me, and so we talked for a minute. He's like, "I'm going to kick your butt," and I said, "Look, this is not my case, okay? So I just got it." And he asked me, he's like, "What would you do?" And I said, "I wouldn't charge it because Florida law states that a brake light being out is not sufficient enough to pull a car over for a traffic light, for a traffic stop." And he's like, "Very good, I taught you well." And he's like, "Yeah, I have a case on that." He's like, "I have a case from like 1968 still controlling that it outlines what lights must be out. I'm sorry, 78. What lights must be out in the back of the car for the cop to pull somebody over? It's considered a pretextual stop." So he said, "Well, why don't you just go up and drop the case?" And I said, I can't do that. I said, I don't have the authority right now because I got to talk to my division chief." And he goes, "Well, you know how this is going to turn out." And I said, "Yes." I went up there and I made the argument like I was supposed to, and he broke out the case, and the case got dismissed. It got dismissed. I didn't consider that one of my cases because it was handed to me that morning, and they said, "Hey, go to court and argue this, right, and argue these other ones." But him and I, Craig and I, we stayed good friends for a while, for a few years afterwards. But that always comes up when I talk to him. But yeah, so he pulled that case out and got it dismissed. Now, had the defendant had a public defender, I don't know if that argument would have been made because public defenders, they have no choice but to move cases along because they're given 400 cases. So the best attorneys I've met, period, are public defenders because they have to know the recent law and they have to figure out where to put their energy and resources. Okay, so they have to know when red flags pop up and what's worth fighting and not fighting. Miami-Dade County is so overwhelmed due to lack of budget still and so many cases that 4 years ago, the elected public defender there, she made a statement and said, we are no longer representing those charged with a third-degree felony. Because the average time that one of my public defenders has, pursuant to the current caseload, is 17 minutes from initially looking at the case to resolving it. And she said, she's like, this is without question a violation of defendant's constitutional rights. She's like, I concede that across the board, but guess what? There's no money. There's no money here. The budget's been cut because of the recession we're going through. Nobody's helping me out at the state level, and so I have no choice. I am going to cut, like no one from third degree, no one that gets charged third degree felony is going to receive representation from my office. And so the ACLU jumps in. It was a huge media thing. You're violating constitutional rights. It went all the way up to the state Supreme Court, and the Florida Supreme Court said in 2011, yeah, she can do that. And it was a matter of public exception because the Supreme Court was faced with the question, what do you do if you rule that the public defender down there was unconstitutional, and then all these, you're talking possibly thousands of people who did not receive representation for the previous, was it 2 years or 2 years, because of the refusal to give them representation. If the Supreme Court held that the public defender was unconstitutional in that, then you have thousands of lawsuits against the state, thousands, right? And they're going to win, number one. And number two, the Supreme Court then thought, well, if we say it's unconstitutional, like we can't force we can't force public defenders to carry 600 cases, which is what they were carrying when they had third-degree felonies. Okay, so basically, you can say it's unconstitutional. Then the state gets sued for millions and millions of dollars and settles out and loses, flat out loses, no question. And then the caseload of the public defenders almost doubles because there are so many more third-degree felonies than first and second-degree down Miami-Dade. And so then the public defenders now have, 600 cases instead of 400, and it slows everything up. And then there's allegations of violations of, constitutional rights weren't observed because it just creates such a problem because there's so much work to be done. And there's no money to hire new people to assist and do it. So the Supreme Court of the state basically had to side with her to avoid the financial and social impact it would cause. So they found a way to do it. Pretty interesting to me. Balancing test. This is an exception. Wait, I didn't go over this one. Yeah, I did, for the poisonous tree. Balancing test. In recent cases, this court, capitalized meaning Supreme Court, has emphasized that in deciding whether to apply the exclusionary rule, lower courts must balance the rule's purpose, which is deterrence of police misconduct, against its costs, which is the exclusion of probative evidence. Therefore, exclusion of tainted evidence, including fruit of the poisonous tree, is not automatic. Whether exclusion is warranted in a given case depends on the culpability of the police and the potential of the exclusion to deter wrongful police conduct. So instead of, the Supreme Court is guided and said, it's not a hard and fast rule. Okay? It's not a hard and fast rule. And there's so much more to explain with that, but you're not law students, and there's really no point to for the purposes of writing a paper for this learning plan. But there's flexibility. What's balanced this? So let's say that the evidence material evidence that would prove the case will be excluded under a successful exclusionary rule or fruit of the poisonous tree motion to suppress hearing. Okay? How culpable, how guilty are the police officers or the single police officer who sees that evidence and the intentional and purposeful violation of the defendant's constitutional rights? And then that's very subjective, because I've been to numerous motion to suppress hearings and I've argued a lot of them. And it's hard to tell. It's hard to tell because the seasoned officers know precisely what to write in their incident report. So like, let's say that the seasoned officer finishes the arrest, the seizure of evidence, and then thinks back and goes, oh, wow, I made a mistake, right? I've never come across a situation where they lie in the incident report or police report, but I could tell who had, if it was written in a way that a mistake possibly was made in the motion to suppress hearings that I went to that was challenged, but it was obviously in good faith, as in it was a simple mistake that was not malicious. There was no intent to put this person away for 50 years. It was a small glitch, and should that exclude the otherwise relevant evidence? Well, it depends on what side of the street you're standing on. I think it shouldn't, okay? But then again, that's a slippery slope, because one could argue that it's always good faith and honest mistake. A hard and fast rule that if any evidence, period, has been proven to be seized illegally, it does not pass go. The case has to be dismissed. That's more of a predictable rule and holding than it is to allow for flexibility in the middle. Now, the only reason, again, that the Supreme Court emphasized in Herring versus United States that there should be a balancing test is because there's simply not enough court personnel to hear every one of the exclusionary rule challenges. It's just not there. Supreme Court, this is the Supreme Court's way of saying, look, okay, you states, you handle it. This is our guidance. There should not be a constitutional challenge on the outcome of a motion to suppress hearing unless it's something completely outside of what we put here. Like this case, this holding in 2009 basically said we're not going to hear any more of these for a long time because we're getting stuck with them. We're getting flooded, and you all need to figure it out down there. That's what this case is. An exception, independent source. Evidence is admissible if the prosecution can show that it was obtained from a source independent of the original illegality. Example, police illegally search a warehouse and discover marijuana but do not seize it. The police later return to the warehouse with a valid search warrant based on the information totally unrelated to the illegal search. The police may seize the marijuana legally. It's Murray versus the United States. Now this one tends to raise a few eyebrows when I teach law school in person, and I'm sure you're looking at this, reading and going, I don't know about that. So if the police illegally enter a warehouse, so they enter it illegally as it is, and then they happen to see contraband, that would be the plain view exception if the police had a legal search warrant. So if a police officer is legally searching a resident pursuant to a warrant, and there is a RPG sitting on 5 pounds of marijuana in their living room, those items can be seized under the plain view exception to the warrant requirement because the police officer was legally there effectuating an arrest warrant. Okay? When the officer or officers do not have a valid search warrant, they can still leave and then go seek to get a warrant to go back to get what they shouldn't have seen in the first place, if that makes any sense. Now, when it says the police later returned to the warehouse with a valid search warrant based on information totally unrelated to the illegal search, police officers cannot go to a neutral magistrate to get a warrant and say, hey, we were illegal, because they're going to say, hey, we were in warehouse 13 and we noticed bales of marijuana. We want to get a warrant to go in there. The magistrate's immediately going to go, okay, why were you there? Oh, we were searching this or looking for that. And the magistrate's going to say, okay, well, did you have a warrant for it to be in there? No. Were there any exigent circumstances to enter? No. Okay, well, you shouldn't have been there in the first place, so I'm not going to give you a warrant to go pick up this marijuana. Is where this independent source exception has been found and upheld by the Supreme Court is when police go in the warehouse, they're not supposed to be there, they see the marijuana. They leave, okay? And then they conduct a stakeout on the warehouse itself, and they have enough visual evidence and probable cause to go and get a warrant to search the warehouse for marijuana. Now, that's still kind of shady to me because the police, in theory, never would have conducted the stakeout had they not known there was something illegal already inside the warehouse, and they shouldn't have seen that because they didn't have the proper warrant to enter in the first place. So I'll let you ponder on that for a little bit, but I'm not sure if I agree with this independent source exception. Exceptions, intervening acts of free will. An intervening act of free will by the defendant will break the causal chain between the evidence and the original illegality and thus remove the taint. That's Wong Sun versus United States. Example, the defendant was released on his own recognizance after an illegal arrest, but he later returned to the police station to confess. This voluntary act of free will removed any taint from the confession. So, in this, again, this example is the Wong Sun case. Defendant Wong Sun is arrested. It was illegal. He is ROR'd. He goes away, thinks about it, goes back and confesses. That's an intervening act of free will. Okay, it's completely separate. And what's considered in these types of cases are the amount of time that lapsed between the defendant being released and when the defendant actually returned. Exception, inevitable discovery. If the prosecution can show that the police would have discovered the evidence whether or not they had acted unconstitutionally, the evidence will be admissible. Now this is an interesting case. And I would encourage you all to look this up. I already searched on Wikipedia, the facts and holding is correct. So you could look there. But in 1984, you had a man who escaped. It was Urbandale Mental Institution. And long and short, he raped and killed a 10-year-old girl, and then he buried her somewhere next to a road or off a road. And he was a person of interest. The police were looking for him, and he turned himself in on the condition that he would not be interrogated. So when he, and again, he's mentally ill here. So he turns himself in, and then a police officer says, "Look, we have snow falling. Take us to the body so we can get her body before the snow falls and ruins our search efforts." And so he did. Now, if he, the cop spoke to him with knowledge he was not to be interrogated, that's arguably interrogation. And obviously someone of lower, not lower, but differing mental capacity, having been in a mental institution, arguably would not understand some of the complex legal concepts and gateways as the police would. So he takes him there, and long and short, the Supreme Court rules, and it was under the Warren Court, and all the conservative justices upheld it, plus Sandra Day O'Connor, who she was a middle of the road, but she upheld it. She was basically the swing vote that brought it over. And I mean, as a holding as case precedent, the court said, well, there were already search efforts underway, so her body would have been discovered inevitably anyway, because they were searching around that area. Now, what and is what the Berger court did, and then the Rehnquist court. It was Warren Berger in 1970. He took over as the Chief Supreme Court Justice after Earl Warren, who was incredibly progressive and incredibly an activist judge. And that's a whole different case. But you had a reign of incredibly conservative Supreme Court Chief Justices, Berger and then Rehnquist. And both of them hated Earl Warren. In fact, Rehnquist once said, "It is my entire judicial mission from here on," when he became Chief Justice of the Supreme Court, "to undo the activist court and mentality that was used to make up law during the Warren era." He flat out said, I want to go overturn what the cases that he found. Under Warren Court, the right to counsel under the Sixth Amendment was established. Brown versus Board of Education desegregated public schools. The right to privacy was found for contraception. And Rehnquist said none of that. And he tried to overturn it, and it just never stuck. But that's how mad he was at the Warren Court. So there's a series of cases that came out during the Berger Court and the Rehnquist Court that were incredibly pro-police and prosecution. They stretched things out as an attempt to, in their mind, balance out the powers and not give the defendant so many powers. Now, what's so stretchy about this case is that, okay, so agreed, let's say that the body was found. But then the prosecution has to prove that the defendant was in fact the one that killed the girl. Okay? That's what the court didn't address. And whether that could have been proven or not, I don't know. Okay? Is it wrong when any child, when anybody is raped and murdered? Yes, no question. But that is almost, that was the shock part of this case. But inevitable discovery has been used numerous times by prosecution for not for murders, but just for drugs and other contraband. So this case truly it did not address the real issue, but they thwarted it and jumped over the proof beyond a reasonable doubt the prosecutor had to prove by going all the way back to going to the discovery of the body and thus the confession. So as a way to get rid of all of the following irritation, I guess, as the Rehnquist court or Berger court would call it, in proving a defendant is guilty. They just went right to the very beginning and said, oh, well, he wasn't coerced and it wasn't fruit of the poisonous tree because the body was going to be found anyway. So very, very much a stretch of the law. How to enforce the exclusionary rule. Right on hearing of motion to suppress, the defendant is entitled to have the admissibility of evidence or a confession decided as a matter of law by a judge out of the hearing of the jury. So motion to suppress does not, the jury sequestered, they're put out of the trial or the courtroom. My motion to suppress were always pretrial activities, so that was decided before we even picked a jury. It is permissible to let the jury reconsider the admissibility of evidence if the judge finds it admissible. That's kind of ridiculous to me because judges, it's so funny when you see on TV, if you've been part of a jury yourself, an attorney objects to some testimony or a piece of evidence and the judge sustains it, and then the judge looks at the jury and says, strike that, or they'll make some kind of comment saying like, strike that from the record. Well, you can't unsee what you've seen. So let's say the judge finds it admissible and then the jury gets to look at it and say it's inadmissible. That means they still saw the evidence and they know what it said. Just because it's not admissible doesn't mean it doesn't affect how they're influenced for guilty or not guilty and deliberation. The burden of proof. The government bears the burden of establishing admissibility by a preponderance of the evidence, meaning more likely than not, 51%, that this evidence that was seized was done so illegally. The defendant has a right to testify at the suppression hearing without his testimony being admitted against him at trial on the issue of guilt. So this is so the defendant can testify as to how the evidence was seized and what happened, and anything the defendant says in this hearing cannot be used, period, or brought up in the actual trial because it could possibly prejudice the jury. Last thing I'll say here, how does this relate to your paper? Well, it is a method of internal and external police accountability, because if the prosecutor can't use the evidence because it was deemed to be seized illegally, and if this happens enough, the police agency is going to have memos go out, retraining done, because what's the purpose of policing if cases can't be prosecuted because of illegal searches and seizures by the police? So those on patrol. So it's a matter of internal and external accountability. Okay, if you have any questions, please contact me, and I will see you all in the discussion boards this week.